And it looks like the recording has started. So welcome to the third department assigned counsel plan overview. We're really excited to have so many people here. There is a need for more appellate and post-conviction attorneys to work on assigned criminal and family court appeals in the third department. And you will hear from Joe Rotello and Rob Marchioni, the assigned counsel plan administrators in the third department, about how the panel works today. We'll then put it up for questions from you all, so you can use the chat to ask your questions. We'll try to get to all of those. And then Joe and Rob would love for you to consider applying to join the panel, and we will send you a follow-up email with information on how to do so after this session. So don't worry about taking notes or getting down emails. We'll make sure that everyone who is here today will hear from us afterwards and get that information. We also want to just note and remind everyone and let people know who may not know that the hourly rate for 18B attorneys increased greatly 2 years ago to $158 per hour for all types of legal representation under County Law Article 18B. And in addition to the higher rate, there are also robust support services available to you, including the New York State Office of Indigent Legal Services Statewide Appellate Support Center. So my name is Mandy Jaramillo. I'm a supervising appellate attorney with ILS's Statewide Appellate Support Center. And I was actually the first hire for the support center when we opened near the end of 2022. And since then, we have done a lot of hiring. We have a fantastic team that can support 18B attorneys in a variety of ways. So our support team, which is led by Claudia Troop, the Director of Appellate and Post-Conviction Representation, includes 7 attorneys, a paralegal, an investigator, and a mitigation specialist. ILS is a state agency that monitors, studies, and works to improve the quality of legal representation provided in New York's county-based public defense system. So while our team at the support center can't provide legal representation or become a part of a defense team, we do consult on individual cases at all levels. So that could be an appellate case, a post-conviction case, trial level, and we do both family court and criminal appeals and criminal cases at all stages. We also consult with our special assistants for investigation and mitigation on investigation aspects of a case, mitigation aspects. And in addition, we create low or no cost trainings, as well as resources that are available on our website. So some of the useful resources that you can find on our website, and again, I will send this in a follow-up email so that you have direct access to these, are guidebooks on pursuing DVSJA sentencing and resentencing, templates and instructions on pursuing 440 litigation, and many appellate resources for both family and criminal practitioners. So without further ado, I want to introduce Joe and Rob, and then I will turn it over to them to talk about the third department assigned counsel plan. So Joe Rotello is a graduate of Lemoyne College and Thomas M. Cooley Law School. He was in private practice for 13 years, and his areas of practice included criminal defense. He joined the third department in 2007 as executive assistant to then presiding Justice Cardona. And since 2011, Joe has served the court as the criminal assigned counsel administrator and is involved with all aspects of the administration of criminal appeals in the third department. Do you want to wave, Joe? They see your name. And then Rob Marchioni is a graduate of SUNY Brockport and Albany Law School, following careers in college athletics and nonprofit management. Rob is entering his 20th year working for the third department, the last 10 of which he has served as the family court assigned counsel administrator. And Rob, your name is on the screen as well. So I'm going to turn it over to Joe and Rob to go over an overview. And then once they've kind of gone through that, we'll take questions from the people in the audience.
Great. Thanks, Mandy. And welcome everybody today. We'll start out, as Mandy said, Joe and I are going to give a brief kind of 5,000-foot overview of the program. And then we figure we'll get into a lot more details in the question and answer period. So as far as joining the panel, as Manny said, it's county-based representation, but the third department actually maintains its own 18B panel. There's no requirement that you be a member of the county panels to be on the appellate panel. So to join, it's a pretty simple process. The application is on our website. It's a couple of pages long. Complete that, send it in with a resume and a writing sample. We do a quick disciplinary background check, present it to the court, and then, you know, more times than not, you get accepted on the panel, and the court will start sending you assignments in either family court, criminal appeals, or both, as you may choose. Joe?
And I guess the one thing to add is, although we do have a few counties that when a case needs an assignment of an attorney, we will check first with that county to see if they have a recommendation from their plan. More often than not, on the appeals, they defer to our assignment. And again, we'll look to our panel for that. There are some questions that come up as far as full-time employment. If you're engaged in full-time employment, public employment, we require a letter from your employer authorizing you to participate in the plan and accept assignments, as payment is made by the counties. Typically, if someone has county employment, we will avoid assigning the attorney to cases that come out of that county. Residence or office in the third department, it's listed on our application as a requirement. Exceptions are made on a case-by-case basis, and we do have attorneys that are on our panel from other counties outside the third department. We welcome applications from those attorneys. Very often, their inclusion in the panel has to do with their experience. And that kind of leads into what support that we offer. There's somewhat, we offer guidance to the attorneys as best we can. ILS is a terrific resource in the appellate support center, and we often refer attorneys to them for more detailed legal analysis type questions. We have a mentoring program where I will pair up often a new attorney up with an attorney who's been on our panel for a while, as questions may come up that it's easier for the two to communicate and guide new attorneys on our panel. We're very user-friendly, answer questions all day long from attorneys and assist in any issues that might come up with client communication, putting the record together, transcript issues, exhibit issues, reaching out to district attorney's office, everything that we can do to facilitate the perfection of the appeal. Typically, depending on an attorney's experience, will depend on the type of appeal that you're assigned. If you're relatively new to appeals, and a lot of folks that are just maybe getting back into doing appellate work, we'll start off with plea cases. Attorneys with greater experience in handling appeals from verdicts will be assigned those types of appeals. And basically at the end of everything, you submit a voucher that's reviewed and is paid in a nutshell. There's reimbursement for certain expenses such as copying costs, digitization of the record. We use NICEF, and Rob can explain that process. It's a little different on family court appeals than criminal appeals, but that's basically, I think, an overview of getting on the panel and what we initially offer.
Yeah, and just to follow that up, Joe, on the family court side, you had talked about experience. You know, we do have attorneys who come in who have no experience at all in doing criminal and or family court appeals. And generally, again, we encourage those people to join the panel. And on the family court side, that usually means starting off with a respondent's brief, so you can get a feel of the process and see a few records before you're responsible for crafting one yourself. So that really leads into the discussion we wanted to have about putting together the record. And I also wanted to mention one thing about assignments on the criminal side. Generally, the assignments will go out without contacting attorneys first. On the family court side, because it's civil litigation and we have so many parties, I will always reach out to the attorneys and give you the party names so that you can do a conflict check. And make sure that your schedule is such that you can accept the assignment. So you don't have to worry about getting overburdened. We generally can provide as much or as little work as attorneys want. As Joe mentioned, all of our both criminal and family court cases are mandatory NICEF cases, so they're e-filed. And generally it is the responsibility of the attorney assigned on the appeal to generate that appeal in NICEF. It's really as easy as putting in some general information about the appeal. It will go to our clerk's office, who will correct anything that needs to be corrected, and then assign an appellate number to that in the system. And then you can start working with NICEF to move the appeal forward. In terms of putting together the record, I'll cover it from the family court side. There's basically two pieces. One is to get the record documents from the court, and the assignment order will direct that the family court provides you with record documents, and as well as produce 2 copies of the transcript. Depending on the county, you'll move through the family courts to order your transcripts. Sometimes they require you to select the transcriptionist. Sometimes the county does. It just all depends on the county. So really, you'll get a feel when you start working for how the counties operate, and you can always call them as a resource. So really, as soon as you get the assignment, it's good to get the record document request in, the transcripts going, because it can take a month or 2 to get those documents. And we actually just recently, in the past, appeals in the third department have always been done via the appendix method. For those of you unfamiliar with that, it was in an effort to reduce the number of copies that attorneys had to make, because again, this is all being paid for on the public fisc. So what that involved was creating 1 copy of the full record, and then pulling out any pages from the record that you are citing in your brief to create an appendix, and then copies would be made of the appendix to go with the brief. We have now fairly recently embarked on a new program where we are allowing these appeals to be perfected on the full record method, which means essentially you create 1 volume that has all the record documents and all the transcripts, and then the brief will cite right to the record instead of an appendix that would be created. So the attorney now has the option of doing either or to perfect the appeal. Joe?
On the criminal side of things, basically everything's very similar with NICEF. The assignment order directs that the attorney go in and establish the case in NICEF. On criminal NICEF matters on appeals are not available to the public. You file the notice of appeal. We have specific instructions on our website, and that we can provide to the assigned attorney for how to establish that case, and it takes you right through perfection on a step-by-step basis on getting a case set up in NICEF. Unlike family court, I don't typically call to see if an attorney is available. As best we can, I have a database where I track the number of cases that each attorney feels comfortable with, what type of caseload that they can handle. It's something that's just acquired over time. Many attorneys are on a will call basis, where I have noted that they'll call me when they are ready for an assignment, which is fine. But I don't typically call first. You'll receive an assignment order. It'll instruct you to upload in the assignment order and the notice of appeal in NICEF. There's no requirements for filing fees on criminal matters. The assignment order will direct you to contact the county clerk's office to get the record material and information. And as Rob indicated, we transitioning, we call it the transcript pilot program. On the criminal side of things, the court reporters, at least it's fully in effect in the 3rd Judicial District, which is 7 capital district counties primarily. And the court reporters have NICEF access, so the attorney's copy of the transcripts will be uploaded right to the NICEF file that was created. You won't receive a paper copy, and from there you'll create the full reproduced digital record. And upon perfection, you'll file 1 copy of that record to go along with your 3 briefs. That is soon to expand in the 4th Judicial District, and then I'm told training will be quick for the 6th, and the entire department and appeals will be perfected either on the appendix method or with the transcript pilot. It's the hope that that'll be the primary source. Most attorneys indicate that putting an appendix together is the biggest challenge right after putting the record together. That's a big difference in our department. It's the attorney's responsibility to put the record together, to gather the record material, and that's why we're here to provide some assistance when there are unexpected delays or any problem whatsoever that is encountered. Sometimes court reporters retired and not responding, and we have procedures in place to guide and assist the attorneys on our panel. Guess case tracking is another important thing that Rob and I are involved in. We are hands-on with all of the family court appeals, which are just about all of them are assigned. Just about 100% of the criminal appeals in this court are assigned. We monitor and track each case. The assignment orders will direct to perfection by a certain date or an extension request. We anticipate that an extension request will be filed. Those requests can be in letter format to update our office on the status of the appeal. If there's an issue, getting the record, communicating with the client, copy of that has to go to the assigned client, and it's a way to update them on the status of the appeal. And we hopefully will soon have a staff person in place that will oversee that in greater detail and attention. And we reach out when attorneys miss filing deadlines for those extension requests and send friendly reminders. But that's our way to track the appeals. Rob has a similar tracking system in place, and I don't know if Rob, you want to point out any differences on your end as far as respondents' briefs go? And
yeah. I mean, no real differences. We try and reach out about a week before a deadline is due, just to remind the attorney to, if they're not going to be perfecting by the deadline, to get an extension request in. We like to keep things current, and so we also track the responding briefs the same way.
And the court rules are slightly different on civil appeals and criminal appeals, and there's a little bit more latitude with criminal appeals and the length of time that it is anticipated perfection will occur. There are delays can vary in putting the record together. So on plea appeals, our goal is that an appeal will be perfected within 8 to 14 months from the assignment date, and it's a flexible date, not fixed. On appeals from verdicts, it's probably 12 months to 18 months, sometimes beyond that. 440s, which you can talk about very quickly, an assigned appellate attorney on criminal matters now has the ability to bring a 440 motion or ask that local counsel be assigned to bring a post-conviction CPL 440 motion. And in our department, we place an informal hold on the direct appeal to allow that motion to run its course and play out. In the event that the motion is denied and leave to appeal is granted by this court, that 440 appeal will be joined and heard together with the appeal from the conviction. The assignment just continues, and we handle that by a simple letter from my office to indicate that, you're now assigned to, in essence, 2 appeals instead of 1. But the 440 process does add a delay, but we do not require the direct appeal to continue, but it's not a formal order of abeyance either. We still want the attorney to file extension requests and update us on the status of the 440, especially when there's a different counsel appointed by the county for that purpose. So that's a little bit about case tracking. And then from there, when the appeal is perfected on criminal appeals, upon the filing of the brief in NICEF, once the clerk's office has reviewed and approved the filings, you'll receive an email communication from that office telling you to file the paper copies and the timeline for filing those documents. I think it's 14 days. It's not a hard and fast rule. If you need an extension, it's just sending an email and notifying them that the filings are on their way. After you've done that, you can submit an interim voucher for your work and disbursements to date. And that's only on criminal appeals that you can submit an interim voucher. And that's and then oral argument. Our court does allow for remote oral argument. It has to be requested ahead of time when the calendar goes out. And if you want to be remote, you need to submit that request to the clerk's office. You have the option, obviously, of appearing in person. And if the case, it's appropriate to do so, to submit. And that's, I think, everything that I have down on at that, perfection to that point. After perfection, we have court rules on criminal appeals that require you to ask your client if the conviction is affirmed, if they would want you to seek leave to the Court of Appeals. And then if they do, you take appropriate action and file that leave application. That would then conclude the assignment, and you would submit your final voucher for payment. A lot of information. The devil's in the details, as they say, and we can certainly answer any questions that folks may have or delve in greater detail based on Mandy's.
Yeah, we've got some questions in the chat. Rob, was there anything different in that process that you wanted to talk about for family court, or is it all similar?
Yeah, it's pretty similar, Mandy. I think the only thing is the timeline on family court is a little quicker. Obviously, most of our family court cases involve in some way parents, or either parent or both parents, not having access to the children. So we generally like to see, depending on production of the transcripts, the family court appeals perfected in the 4 to 6 month time period, with a quick turnaround time for responding briefs. For family court appeals, they do get put on the first available calendar. So in a sense, they get a preference. So they move a little bit more quickly. And that's one of the reasons Joe talked about interim vouchers being allowed in criminal cases, and we don't accept it in family court cases. And, one of the reasons is that we expect them to move through the process a little bit more quickly. So naturally, you get paid a little bit more quickly.
Okay, so I'm going to ask some of these questions from the chat, and please feel free, anyone else who has a question that hasn't put it in here, just put them in. We'll try to get to everything. So one question is about who pays the voucher. Since you are the administrators of the third department, does it still go through the county, or does it go through the third department?
So vouchers are submitted to the third department. We audit them and issue a payment statement or payment order. It's returned to the attorney for submission to the county for payment. Counties it differs from one county to the next. Some counties receive their payments order and will issue a check. Other counties have almost a vouchering process where they want you to resubmit a copy of your statement. Assured that it is not a secondary audit. They understand that our issuance of an audit is the review, but for satisfy their internal finance requirements, they want supporting documentation with each check that they issue. Again, varies from county to county, but it is a county responsibility. As far as costs and disbursements, the outlay of costs and disbursements is the assigned counsel's responsibility. We have a disbursement cap of $750, and to exceed that, you have to request permission from our office for that expense. It's a cost control measure. There seems to be a very distinct and large difference between the cost of printing and compiling a record for digital filing and even copying from copy centers in upstate New York as opposed to downstate, a very significant difference. So if anyone interested in joining the panel is on the panel, there are certainly not services that we recommend. There's the ones that attorneys on our panel frequently use. We have, contact information for all of them for you to do your research and talk to other attorneys on the panel, perhaps, and go from there. But it's your responsibility to front those disbursements, and it's typically never an issue with being reimbursed disbursements. But if there's any questions, we always encourage people to ask on the front end. The disbursements are primarily copying expenses and mailing expenses. There may be some travel expenses involved if you're coming to court for oral argument, and it's mileage is paid at the state rate. Time is paid as well.
And going along with that, there's a question here that, do you require physical briefs? So obviously, if people are copying, there is a requirement. It sounds like there might be a difference, though, between which method is used. If the transcript pilot program is used, is that less physical copies or?
Well, the idea, 3 copies of the brief are required to be filed, 3 paper copies. Obviously, there's 1 digital copy in NYSEF. If you're using the appendix method, each brief must have an appendix that's filed with it. In the what we affectionately call the transcript pilot program, it's a hybrid full record method. You're creating 1 digital record of the full reproduced record, and only 1 copy, a paper copy, hard copy, is filed when you submit your 3 hard copies of the brief. So you don't need to submit a copy of the record with each brief. But on the appendix method, you do. There could be some records where it's more feasible, makes more sense to do an appendix if you have a 10,000 page record and your appendix would only be 300 pages. Mm-hmm. We'll have some built-in flexibility now as opposed to requiring only the appendix method, because that is very time consuming to put together, and we're trying to make it easier to perfect appeals in the 3rd department. And that's one of the things that we were able to come up with, and seems to be working. We've had in Albany County, it started in 2022 with getting it off the ground, and it's taken hold, and everybody seems to be pleased with it. Obviously, the idea or the thought is we will eventually be at no paper copies. We recently just reduced it from 6 to 3 this past year.
And another sort of, I'm going through the payment questions here. So, and you got to this a little bit, Joe, with the, getting paid through the county, and obviously it varies by county, but can you give a sense of the timing of payments? Like, how long does it take to get paid after submitting a voucher? Are there significant delays, and what would cause those?
So from our perspective, if there's a significant delay, it's usually a result of of staffing. We've had as with every place else, a lot of turnover and different assignments. There's an ebb and flow to the volume of vouchers that we receive at any given time. But generally, once a voucher is submitted, the payment order will be returned to the assigned attorney within 30 to 60 days. Submission to the county, it varies from county to county. I've heard stories with certain counties taking multiple months before payment is issued. I think generally it happens in a few weeks, but it does depend on the county. You take your larger counties, and Broome County, Schenectady County, Albany County, Rensselaer County, as far as volume of criminal appeals and probably volume of trial level matters. The offices are processing a lot of vouchers. The biggest complaint I hear on delays will come toward the end of the year as the fourth quarter is ending and budgets are itemized budgets for the county is funds in certain accounts are dwindling, and there can be added delays just because of that, but that's entirely within the counties. I will use this opportunity to tell people that are looking to get on a panel or going into private practice with the idea that they're going to get on the panel. Your first assignment, you're assigned, it can be 4, 5, 6 months before you can even start putting the record together. Assuming you're not working on anything else and you put that record together quickly, get your legal research done and communicate with your client, who's 10 out of 10 times is typically incarcerated, and get your brief filed. That's only part of the process, because now you have to have the respondent's brief filed. But at least now you're looking at 8 to 10 or more months after you've had the assignment before you can perfect the appeal. And that's when you submit your interim voucher. And so it's some relief, but you're not going to see that first payment order for, 10, as a practical matter, 10, 12 months after assignment at the earliest, once it, gets submitted to the county. And then interim vouchers are not always paid in full. It's not a cut or a permanent cut. It's just the policy of the court to, in some instances, a partial payment will be made. The final voucher that you submit will include the full request with an adjustment for any interim payment. But the process, final vouchers are reviewed by the court that heard and decided the appeal, as they're in the best position to evaluate the work product of the attorneys and assess the payment of the final fee request.
Yeah, and Mandy, I just want to jump in and say on the family court side, similar time frame in terms of getting paid from the start of the assignment, but again, that's on the front end when you're starting up. If you accept assignments routinely, then once you get that first payment, you've been working on other cases. So then the payment seems to flow pretty steadily. In terms of turning vouchers around, same time frame for Joe. Family court, maybe we're a little bit quicker, but you can look for about 30 to 60 days. And I have not heard a lot of issues from attorneys about the counties paying timely. Usually if there is an issue, it's because there's somebody new or somebody not in a position at the county. But again, I'll take this opportunity to say that Joe and I are very accessible and are very involved in each case. So if there is an issue with getting paid for the county, I'm always happy to call over and get to the right person to say, we have a voucher over there that's getting hung up. Can we get to the right person and get this paid for our attorney?
Great. Another question, what is the typical amount of hours billed to each case, or a range if it varies widely? And maybe we'll start with Rob. on the family court side, and then talk about criminal.
Yeah, I mean, it obviously varies very widely depending on what type of case it is. You know, we have simple appeals from the denial of an order of protection that may have, you know, a 25-page record in one issue. And then we have, you know, custody cases that have been going on for years and have thousands of pages of transcripts. So it really is particular to each case. I mean, if I would say a ballpark, you know, we're probably looking at briefs of about, I don't know, 20 to 40 pages. But again, every case is particular, and so again, you know, depending on the experience of the attorney, you know, we're going to give those single issue cases usually to attorneys with a little bit less experience, and the more involved Article 10 cases, Social Services Law 384B, which is permanent neglect, which usually results in the termination of parental rights. You know, those are going to go to more seasoned attorneys, you know, usually larger records and a little bit more complicated.
And on the criminal side, on plea cases, it would say if there was an average, it would be between 30 and 60 hours. Most are on the lower end, probably 30 to right around 45 hours on a plea appeal. On new attorneys to the panel, we are aware that they're adjusting to a new process. Attorneys that are doing it for the first time, there's some learning curve that is built into that, but generally that's the range on a plea appeal. On a trial, it can be 60 to 150 to 190, 200 hours. Again, it depends on the size of the record and any issues that might come up. It's almost easier to explain it in dollar amounts. Getting used to the higher amount, because basically the fee awards doubled, and on a plea appeal, it was typically no appeal exceeded what was the cap of $4,400. So now a typical plea appeal is still under the $10,000 cap, and falls in the $7,500 range, where appeals from trials often exceed the statutory cap. So there is a statutory cap. The fee is $158 an hour. If your fee request exceeds $10,000, you need to submit an affirmation of extraordinary circumstances to demonstrate what the case presented that required the additional time. It can be the mere fact that it's an extensive record, but usually it's a combination of things. It can be difficulties in obtaining the record material and having to go back to county court for settlement proceedings and reconstruction hearings. That, you know, or there's a 440 now that brings in an additional layer. Any other difficulty that you've had with the appeal beyond just novel legal issues can establish extraordinary circumstances to justify paying over the award. But it's a legal threshold, which is on vouchers. Everything else is typically administrative, with the exception of that determination that the court makes from a legal perspective. And it's a finding that the case does warrant payment above that statutory cap. But those are the price, kind of the ranges of vouchers that we typically see. And, you know, it's anything above, you know, the $30,000 amounts are the outliers and not common. More so, I mean, they can be with the new rate, but typically, you know, that's what we say.
The only other question we have here in the chat, and I encourage anyone, because we're getting to probably the last 10 minutes here, that if you do have a question, please put it in the chat and we'll answer it, but is just whether this recording will be available to attendees. I believe it will be, but I don't know the answer of that for sure. I think we're going to try to find a way to put it you know, in cloud storage, and to the extent that someone wants to see it after the after we're finished here, just reach out to our email that we'll send you, and we'll try to get you a copy of it. Any other things you can think of, Rob and Joe, that you feel like maybe you didn't get to? We've got a few more minutes here, and then I'll just kind of remind folks of what we'll send them in an email after this is over.
I think I would just loop back to getting on the panel is a relatively basic, easy process as far as submitting your application, your resume, your writing sample. It need not be a 70-page brief. It can be an excerpt, 3 to 5 pages of that brief. Emailing that to the assigned counsel email address. The application's available online. And on our assigned counsel webpage. If there's full-time public employment, submit your letter from your employer authorizing you to serve on the panel. Follow up and call with any questions you might have. I usually have a rather lengthy conversation with the new attorneys about our process and some of the nuances and how things really work, the nitty-gritty. We are hoping to get back to having some CLEs with the nuts and bolts of perfecting criminal appeals in our department. We're working on a redraft of our assigned counsel handbook that hopefully will be a step-by-step guide and again, a nuts and bolts resource for attorneys on the panel to reference. Can't reiterate enough our accessibility. I mean, I get the comments all the time of how we are accessible. You get to know the administrative assistants that Rob and I work with, who are terrific. There are folks here that work in just the family court side of things, both in the clerk's office and in our office, and likewise the same for criminal appeals. Everybody knows a little bit of everything here, but those are folks primarily whose primary responsibility is criminal or family court matters. We are user-friendly, to keep saying it over and over, but we are and accessible, and we assist as best we can in providing guidance, and where we can't, at least directing the attorney to a resource, whether it's a ILS in the Appellate Resource Center, or NISDA if the attorney's a member of the New York State Defenders Association, and some of our other appellate counsels where we may know that who has had a similar issue or might be able to offer some suggestions. We encourage everyone to join the ILS listserv. It's a great resource, and there's terrific questions that get thrown out at any given day, and it's an ability for people to connect to other assigned counsel. So we encourage everyone to apply, and we'd love to have you on the panel. There is an absolute need. There's been a dire need for a number of years primarily, I think, on the criminal side of things. The amount of appeals that we have to assign are enough to keep folks busy. A lot of attorneys have different situations that they're incorporating the work into based on where they are in their professional career. And we do everything we can to accommodate the preferred work as far as what they like to receive.
And there's a couple more questions, so I want to make sure we get to those. But I just want to also just ask, will you consider people right out of law school? Like, will you consider people who really don't have any experience but kind of want to get into this work?
Yeah, absolutely. And that, either seasoned attorneys who may not have practiced family court or criminal appeals, or people right out of law school. Again, we have programs to set them up with mentors. I just want to reiterate what Joe said. We are very, very accessible by phone, by email. We pretty much prioritize answering attorney questions. We're very involved in every case, ushering it through the process, try to make it as easy to practice as it can be for attorneys. And it's a great way to supplement your income. It's, you're not chasing down clients. You do the work when you want, where you want, and the payment on the back end is consistent. So I would, and again, the resources that are available between the court and ILS, we will help you learn the ropes, and so I wouldn't let the intimidation factor keep you from giving it a shot.
Okay, a question about the cap here. So what if you asked that you're going over the cap but you're denied your request to go over the cap? The question is, do we make the application as soon as we go past those hours and know the response, or does the attorney just sort of assume the risk they might not be paid for time in excess of the cap?
Well, there's no requirement to ask beforehand, and really that wouldn't be appropriate anyway, because we don't really know everything that's involved in what the attorney is doing in the process. So I guess in a sense, the attorney assumes the risk. What I can tell you is, when we process the vouchers, when the court looks at them, we know what went into the appeal, and it's not frequent that we never just say, the cap is the cap, and when we're not going to go over it. Most times it's appropriate. As Joe said, in criminal appeals, the fact that there is a trial is probably extenuating circumstances in and of itself. Same thing in family court if there's extensive transcripts. So by and large, we know the work that goes into it, and if it's appropriate to go over the cap, then it's not going to be an issue to get payment for it.
Yeah, and it is, to reiterate, and it's not something that is pre-approved. And to be clear, I mean, the same is true for a voucher that's submitted under the cap. So you're doing the work, you put your time down, you submit it to the court, and if there's an adjustment, the court may make an adjustment, even for a request that's under the cap. A lot of times if that happens, we'll get a phone call to say, do you know why it was adjusted? And there may not be a reason that we have, or just like any other court decision, our answer is the decision speaks for itself. Where, in those rare instances where we've been contacted by the court because of a work product issue, the most common thing is sometimes attorneys that are using canned paragraphs in law that from other briefs. You cut and paste something from the wrong case. You might see an adjustment as a result of that, and it can happen inadvertently. So you always do, in essence, assume the risk. You take the assignment, you do the work that's necessary, you submit your voucher, and the court will issue a payment based on their review and an assessment of that. And if there's any questions, with something that's submitted, and again, this is rare, upon reviewing it, we may reach out and for clarification or suggest something different in the next time, or if there's an issue.
Rob, does the third department have an attorney for the child panel for appeals?
The court does have an attorney for the child panel. It's a separate application that goes to the attorney for the child office. It's a little bit more rigorous. I believe there are some training requirements to get on the panel, but we can certainly provide. You can go right on our website and select the AFC office and contact them and learn about their application process. But or feel free to contact us and we can give you that information. But yes, it's a different panel, but we do have an appellate panel.
Is it possible to be on that panel and your panel, or is that?
Oh, absolutely.
Okay.
There are a lot of attorneys that are on both panels.
I think there's a question, how many pages of annotating the transcript is expected to be completed per hour? I think that's in like, let's say you have a really long transcript and you're going through it. Do you guys have a sense of like how long that takes or how many pages per hour?
So
You
you wanna
know,
tackle that?
that's, yeah, there is there's no set time frame. It's looked at from a reasonable standpoint based on the attorney's experience. Um, I think generally when you look at how long it takes, how many pages an hour should it be taking? We've looked at some averages. I think it's 40 pages an hour is a fair average that we've seen. That is not a marker. It's just that we wanted to see, just out of curiosity. It did that years ago. But otherwise it just depends. There's more when the vouchers come in, and let's just say the lion's share of appeals here are pleas, and they are, and you'll have 10 vouchers that are in, and they're all in a certain range. And that range is that $7,000 range, give or take $1,500. So if you look at record review time, because your allocation is should be broken down, and that should be a category, time reviewing the record, you see some consistencies there. And that's where it'll, if you have a similar record and your request is $12,000, well, that, and as timing would have it, your voucher is submitted and there's 8 others that are in that other range, that might draw attention to that issue and how much time was spent. And is there an explanation for that? And very often there is. It's just, so it's not a science at all. It's a reasonableness. We strive to be consistent and fair. Recognizing the attorneys are in private practice and they're doing this work, but, and this is supported by case law, there's a recognition that you are being paid by taxpayer dollars, and it's assigned counsel work, and that you might not get paid for every minute that you spent working on a file. And that's part of assigned counsel work, and I think most of the folks generally understand that, although we don't look at it from the standpoint of trying to cut people. We pay them for their time spent, generally on a reasonable and appropriateness standard based on the case.
Yeah, and Mandy, I just wanted to say one more word about it. We seem to be spending a lot of time on this. This is really not a case of we're trying to find ways to cut corners. It really is a reasonable standard. And I can tell you that in the family court realm, we process hundreds of these vouchers that go to the court every year. I would say on the family court side, probably less than 5% get cut. And if it's a cut, it's probably because, again, because we do hundreds of these, we may look at, a brief and the issues it covered, and we know that brief usually takes 30 to 40 hours for our typical panel attorney, and maybe the request is 70 or 80. And we look at that and say, that's an outsized request for that size brief covering those issues. And that would be something that the court looks at, but it's not something that anybody's looking to cut vouchers.
All right, so we've got 5 minutes left. We've got one more question for you, Rob, a quick question, and then I will just kind of remind everybody of our, what we'll send you in a follow-up email. But Rob, for the Attorney for the Child panel, how are those vouchers submitted and paid? Is it through the AFC office?
It is through the AFC office, and they have
Okay.
a totally different billing process, which I don't know that much about. So that goes through that office. And again, if you contact the office, They are looking for appellate AFCs, and I'll be glad to give you all the information, answer any questions you have.
Great. So thank you all so much for coming. Joe and Rob, thank you for your time. And they really are hoping that many of you will put in applications to be part of the panel. So we're going to send you that information and links to the Third Department website in a follow-up email. We'll also send you some information from ILS's Statewide Appellate Support Center so that you know how to contact us, how to fill out our intake form, and how to ask for consultations on individual cases. We hope in the future that we can work with Joe and Rob, that ILS can work together with you guys to help with putting out more resources and some appellate basics trainings. So we're still in conversations about trying to make that happen. And I think that's all I've got in terms of, we'll make sure that you've got access to our website as well. And so you can see the resources that we put on there as well. But thank you all. And Joe and Rob, I don't know if there's anything. Yeah, go ahead.
I mean, Mandy, thank you and everyone at ILS for facilitating this and making this happen. We have been on an extended campaign to increase our numbers, as that's where we are. There's an absolute, as I stated before, primary need, urgent need to add attorneys to the appellate panel. So we encourage everyone to apply and start taking cases.
All right.
All right.
Thanks, everyone.
Thank you. All right.
Thank
Have
you,
a great
Mandy.
day. Thank you.
Bye.
Bye-bye.